Welcome to the Expert Network Team podcast,
where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business nature.
We hope you will find our content useful as well as entertaining. The Expert Network team consists of Carl Frank of A&I Financial, Mike Miller of Miller and Associates CPAs, Jeff Kromendijk of Security First Insurance Agency, and I'm Nathan Merrill. I'm an attorney at Goodspeed Merrill.
Together, our independent team combines our expertise to provide you insights and solutions, some straightforward, some profound, for real-life opportunities we see on a daily basis. We hope you enjoy the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
And we encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Now on to today's podcast.
Yeah, so welcome to your Expert Team podcast here. We've got Carl Frank from A&I Financial, as well as Nate Merrill from Goodspeed Merrill. My name is Jeff Kromendijk from Security First Insurance Agency, and we have a very special podcast for everybody and all of our listeners here today. And I'm going to turn it over to Nate to introduce our special guest.
Yeah, so today we have with us one of our exceptional corporate attorneys, Lauren Snow from our corporate group. Welcome, Lauren.
Thank you. Happy to be here.
And Lauren does a lot of things with us at Goodspeed Merrill, but one of her particular areas of expertise or interest is in the area of intellectual property. And some people may be familiar with what intellectual property is. I will give Lauren a little bit of an opportunity just to give us a background, kind of a remedial understanding of what we're talking about when we talk about intellectual property. But her expertise is in developing corporate structures and contracts around intellectual property, among a lot of the other stuff we do that most people are familiar with for Goodspeed Merrill in terms of corporate structuring and transactions and that sort of thing. So Lauren, why don't you tell us a little bit about your background perhaps, and then also a little bit about just kind of a primer on what intellectual property is, what that actually means.
Absolutely. So I've been practicing since 2016 in Denver. I've been with Goodspeed Merrill since November of 2019. And I work in the corporate practice group, as you mentioned. Generally, what we do in the corporate practice group is we act as general counsel for a lot of our clients, which are small to medium-sized businesses, and we do everything from formation to dissolution and everything in between. Today, I think we'll focus specifically on intellectual property and give a very, very basic primer. Of course, with anything in law, there are always caveats and exceptions. So I'm just going to give the bare minimum, and I'm happy to answer any questions anyone has following up, or if you guys want to chime in with any questions, please feel free to do so.
Well, what is intellectual property? What does that even mean?
So intellectual property is a very broad word. It covers a lot of proprietary rights and inventions, artwork, brands, and other tangible and intangible property that can provide value for you or your business. Intellectual property, we tend to think of it in two forms, hard IP and soft IP. And the hard stuff is things like patents, patent rights, and soft IP is what people tend to think of when they think of intellectual property, things like trademarks and copyrights and trade secrets. There's a lot that we can do in terms of on the corporate side, not just filing applications for things like trademarks and copyrights, but there's a lot of licensing and a lot of other things that people don't really think about when they're starting their business or forming their business that can actually provide value. So when you do get to the part of your life cycle in your corporate life cycle where you're ready to sell the business, those are things that can actually add a lot of value to your business.
Lauren, is there a easy way to remember the difference between hard and soft IP? And is there a benefit to even knowing the difference?
I think that's a great question. As far as what my capabilities are of a transactional attorney, I don't do a lot of work with patents. And so we tend to think of those as being the hard stuff because you really have to be a patent attorney, meaning that you have some kind of hard science background to provide a lot of value as counsel for patent applications and things like that. What we do with patent rights are things like licensing and things like non-disclosure agreements, which we can get into later. But those are really, that's the hard stuff. And then the soft IP are things like trademarks and the happy, fun artwork stuff.
Ah, now I get it. And an NDA, a non-disclosure agreement, is a hard type of IP.
That would be something that would go along with the hard type of IP, and it will come up with almost every type of IP. And I do have to apologize in advance. I will use a ton of acronyms, so catch me if I do that, but non-disclosure agreement. And a reason that's really important with things like patents are when you file your patent application, you disclose that to the world. So a reason that we would draft an NDA for someone with a patent is that we don't want to disclose that to the world yet. We want to keep that a secret. So that's something like a transactional attorney like I would be doing for someone with a patent.
Got it. That makes sense.
Yeah, so this is really, really interesting stuff, Lauren. Thanks for being here. Looking forward to learn more about this. But so we understand that once something is patented, there's obviously value that is grown in that. There's obviously just a real
like R&D and technical expertise and kind of the innovation
exactly
is wrapped up in the property rights. And so, you know, one of the things is these are often referred to as intangible property, meaning you can't actually wrap your arms around a patent. You can wrap your arms around the product that's produced under a patent, and that becomes a tangible asset. But the intangible rights, and this could be, you know, copyrights on books or, like she said, trade names, trademarks. These are things that are just kind of out there in the ether.
Mm-hmm.
And that's why they're intellectual in a sense. They are not tangible property. They're intellectual property. They're thoughts, they're ideas. They are processes, you know, things that are unique or proprietary, I think is a key word. Wouldn't you say, Lauren? Proprietary developments are the things that you want to protect as a business person. The ideas that are unique to you that you came up with that don't just exist out there in the general forum, the general, I don't know, what's the word for that?
Common knowledge.
Yeah, but so those are where Lauren really kind of dives in and looks at what those rights are for individual businesses. What are their unique assets? And then developing a strategy to actually protect those rights. So maybe you can speak to that a little bit, Lauren.
Exactly. Absolutely. Yeah, so there are a few different types of what we consider to be intellectual property. And for very, very basic purposes, I'll narrow it down to three. And we have patent rights, trademark rights, and copyright rights. And going back to what you said a little bit, so it's the idea, like it's the intangible idea, but there are certain things that you can't patent. So you can't just patent an idea. The purpose of patent law is to promote the progress of science and the useful art. So it really is to promote innovation, and it really is to incentivize inventors to keep inventing products. So what the purpose of having something like a patent is that you have this right, you have this economic interest in developing things and furthering science and technology. And that's why we incentivize people to do that by giving them patents and by giving them rights in these inventions that they're coming up with. So there's a couple of different things that go along with patent. First of all, it has to be eligible for patent registration. So it has to be functional. Things that we look at are like if there's processes, machines. I heard you say a couple of those things. Articles of manufacture, so things that you create, and compositions of matter, which would be like things like nylon. So it has to have it has to be eligible under the statute. Things like music, artwork, those kinds of things aren't patentable because they're not what we've decided is eligible to be patented, which are things like the processes, things that you would generally think more along the lines of an invention. They also have to be new.
Using your music as an example, one of my favorite examples of this for those of us from the 80s.
Oh, yeah.
70s and 80s. You all know Boston, right?
Boston, absolutely.
Who does not love Boston?
Come on.
Well, exactly. So, but the lead guitar player for Boston developed his own analog distortion. It's called the Rockman. And so it's a very unique sound to Boston because he was an electrical engineer. He developed it himself and he patented it. So now he owns all the rights into the Rockman sound, even if it's sampled and put into another machine. The reproduction of the sound is essentially wrapped up in the patent, as I understand it.
So a patent is more than a feeling.
Yes, Carl, way to go.
Oh, that dated
very
me.
good.
Yes.
That is really good, though.
That was good.
That was not scripted at all.
So, Lauren, tell us a little bit more about that, because I think clearly Nathan just went ahead and kind of got us thinking a little bit outside the box from probably what was the general standard that you just laid out. I mean, how difficult is it to really draw a line there? I'm sure Mr. Business Owner feels like he's got a patented product, and then you are probably going to go to the records and the historical data and maybe even do some research with regards to how patentable this particular product or process or idea or concept is. How much of a problem does that pose for you in your position?
Well, I think that's a great question. It's not just about the what the actual product is. There's a lot of other boxes that we have to check. So even if it doesn't meet that subject matter eligibility per se, so even if it is something like music, even though I just said it's never music, even if it is something like music, if it meets these other criteria, that's what the U.S. Patent and Trademark Office is going to look at. So things like if it's useful is a big part of patent protection, and being non-obvious. Those are things that are going to make a bigger difference rather than it just being fitting into one specific box. Does that make sense?
So just throwing out there an example, what about like using sound waves as some sort of therapy? You're not patenting necessarily the existence of the sound waves. You're patenting, is that what they call a use patent or something like that?
Like a utility patent? Yeah, so something like a therapeutic kind of sound wave, like sound baths that people are doing nowadays. It would have to be like the actual process is what you would be patenting. So it would be if you were doing the computer programming of it in a very specific, non-obvious, new, novel way that's promoting arts and sciences, that would be something that would be capable of patent protection.
So as folks are out there kind of, the way I look at it is sometimes inventors don't realize they're inventors. They're just solving problems. They don't just sit there with beakers in front of them or, electrical things, that they are actually practically addressing a problem that they've identified. So when someone's come up with what they feel is a unique solution to a problem, what's kind of the first step? How should they approach even exploring whether they've got something that can be protected?
The first step I would say is call Goodspeed Merrill. We can be reached at 720-473-7644. I definitely, if it's a patented, if it's an invention that anyone thinks, if you have any idea that it's going to have any kind of value, talk to an attorney first. The first thing I would recommend doing is getting some kind of non-disclosure agreement in place, because once you publish, or even by telling a friend about the invention that you have that could be considered publication, and you can lose rights to filing your patent. The more that the more people know about it, or sorry, the less people know about it, the better. So what I would do is
don't get super excited about it and put a video on YouTube or Facebook saying, "Hey, look what I just figured out."
Exactly, because someone else could take that idea and run and patent it, and they would have priority rights over yours, even though you came up with it first. And again, I'm speaking a lot in general terms, and there's always caveats and there's always exceptions. But I would say, the first thing you really want to do is start developing the product. And something you mentioned earlier was the research and development part of things. That's one of the biggest parts of the patent application, is because you have to show the practical application of your invention. So you have to be able to spell out exactly how it gets made, or exactly whatever the process is. And you have to show that it's useful. So you have to, in your application, you have to show what kind of problem it's solving. So you want to get to that point to where you can have a very well articulated application, because you can't take that back later or add to it later.
Right. I'm gonna shift gears a little bit and kind of move us towards the soft side, just in a slow transition here, and by talking a little bit with you about one of the more well-known inventions in the universe that actually isn't patented, to my understanding. And maybe you can speak a little bit as to why someone might not want to patent something. But to my understanding, Coca-Cola, the formula for Coca-Cola, is nowhere registered or patented or anything like that. It's just simply a trade secret. So why would Coke not want to patent the process for making Coke? And if that's the case, if that is one of our clients, what do you do otherwise to make sure that you don't lose those rights? Or how would they go about protecting Coke, and how would a client go about if they choose patent is not the right process or approach for them?
I think that's a great question. That's something that would come up during a consultation with us. One of the first questions that I would ask is whether this is something you actually want to be published, or you want people to find out about, because a patent, the purpose of the patent is to disclose the whole thing, right? So if it's something like a recipe, once other people know that recipe, then the value that's inherent in your product is immediately gone, right? So the value that Coca-Cola has is because it's a secret. So the fact that they've kept that recipe a secret for so many years is the value that's been derived to their brand. If they had a patent, it would be out into the public knowledge. Everyone would know about it. And 20 years after the publication of it, anyone would be able to use it, recreate it without having any kind of payment towards Coca-Cola. But by keeping it a secret, then that's how they're deriving value to it, just not. I am guessing a lot of non-disclosure agreements. I would think that's the biggest thing, is just they probably have a non-disclosure agreement that everyone signs once you see the recipe, or before you see the recipe. And there's probably something like millions of dollars that you would have to pay if you disclose that information.
So the non-disclosure agreements for those who are privy to the recipe are punitive, in the sense that if they disclose it or known to disclose it, they can be prosecuted for that. What other protections, if you're relying on just simply trade secrets and protection of proprietary information, what other steps do you need to take as a business to ensure that you're going to be afforded those protections?
Well, I think you have to be, I think it depends a lot on the non-disclosure agreement, but the size of the penalty is what is really going to deter people from doing it. So it could be, millions of dollars if you disclose it, and then at the same time, we can come to your business and put an injunction on and stop you from disclosing it any further. Those, I think, are the biggest ways that you would protect that. And then you just really have to limit who you give information to. So it would be, very, very few people would actually have the information. I'm sure that it's, maybe not even executives. No one, on the line knows what they're putting into the mix, but
the proverbial ball, or breaking up the process so that no one person understands the entire mix. So
yeah.
So I did want to use that as a segue to kind of address, because I know we have a lot to cover in the kind of a broad overview of intellectual property, but let's talk about trade dress and trade names and stuff like that, because how do you protect that? I mean, there you're just putting words together, right?
As far as a trade dress and trade names, and I'm going to separate those from trademarks. A trade dress is something like when you go into a Taco Bell and everything looks exactly the same. That's, every time there's a franchise, everything looks the same, from the colors on the wall to whatever chairs they're using. That's what trade dress is. That is something that's a little harder to protect, because that all goes into what people with franchising. You have the right to that. Look, no one else can make a similar looking restaurant for the protection of what your brand is. So let me take a step back, because I want to lay a little bit of groundwork into trademark law before we jump into the more nuanced parts of it. Trademark is something that you can think of as consumer protection more than anything. So trademark is one of the oldest forms of intellectual property law. And actually, the first legislative act was in 1266 under the reign of Henry III, who required all bakers to use a different distinctive mark for the bread that they sold. And the idea is that if you got a certain, loaf of bread with someone's logo on it or someone's mark on it, then you'd know exactly where it came from. And it really is to protect the consumer. So the value in trademark is not, it's not just as soon as you start using a logo or something, you have tons of money, or, you've generated a bunch of economic value to your company. It's really in the brand that you've created and the reputation that you've generated throughout the marketplace. So when there are things like, going back to kind of like the Taco Bell example, there's value in their source identifiers. So whatever they use, like their logos, their colors, their brand, that's what their value is, because people know that when they go to a Taco Bell, they're going to get a certain quality and a certain type of product. So when we have something like trade dress, that's the idea, is that you're the only one who's using that specific type of chairs or cups, or however you're doing things. That's your trade dress.
Got it. So move on to trade names and trade. I mean, probably then the most common form of initial intellectual property protection a company might want to pursue then is trademark and trade name.
Yes, definitely. And so trade names are just, we think of those as what name you're using in the industry, so it's, or in whatever industry you're participating in. So it's not necessarily your legal name. A company could have a completely different legal name and then use different trade names for whatever brands they're using for that specific product. And the trademark is, I think that it's wildly misunderstood. And I feel bad for trademarks because I think they get a bad rap sometimes. But people really don't understand how valuable their name can be and their brand can be. And people put a lot of money and effort into creating a brand and marketing their products. And a trademark is a very, very effective and sometimes very cost-effective and easy way to add value to your company. And that this is, the brand that you're creating. And when you go to sell your company, if you have things like trademarks already registered, you've already got some assets in your company, even if there's not a lot else that you have going on yet.
So, and sorry, I'm going to actually ask a question targeted towards Carl and Jeff here in a second. But so one of the things I just heard you say, though, that I think is important for people to understand is securing your intellectual property. If you are developing a business that's a saleable business, is crucial to that ultimate transaction, because if you come to the table to sell your business and you can't show that you own your trademark and your trade dress and your proprietary information, and you're trying to sell that for millions of dollars, you're going to get slaughtered in the negotiations, because they're going to say you don't own it. Is that a true statement, Lauren?
Yes and no. That's every lawyer's favorite answer. It depends. Um, so to go back to when you're filing for a trademark, there's a few different ways that you can have a trademark. So there are common law rights that you have just by entering into commerce, just by putting a name onto a product. You do have certain common law rights. So there are some trademark protections that you would get for that. But it's very limited and it's very hard to prove. And you have to really show that consumers in the industry in which you participate will see that logo or mark and know that that's you. So one way that we as attorneys take a shortcut is that we can file trademark registration, and we can do that at either the state or the federal level. At the state level, it's usually with the Secretary of State. It's usually very inexpensive, and it's usually immediate. So there's not a lot of reasons why you wouldn't do that at the state level. At the federal level,
that gives you protections within the boundaries of the state only, correct?
Correct. And at the federal level, you can file with the United States Patent and Trademark Office. It's a little bit more expensive, but you have nationwide rights. So you'd be able to enforce your trademark anywhere in the country. And you do have to have your goods and or services enter the interstate commerce. And one way you can do that is by showing that you can sell your product or service through a website, and that way you can kind of show that it's being used throughout the country. But it is a little bit more expensive and takes a little bit longer. So for example, where state trademarks are immediate, federal trademarks can take anywhere from 8 to 12 months.
So aside from the value, the other thing I heard, and this is where I want to loop in Carl and Jeff to kind of get some business person's perspective on this, but the other side of what I heard you say earlier is that trademarks origins is really in consumer protection, meaning they're trying to protect the consumer from being confused that they think they're dealing with Security First Insurance Agency when in fact someone's just knocked off Security First by calling it something very similar, or they're trying to leverage Jeff's reputation into Security First Home Security or something like that. So first, I want to just throw out there, have you guys done any specific protections of your own on, because I know you have a very distinct logo for both of you have very distinct logos for your companies. Have you done anything to actually seek protection of those, or what curious what you're...
Man, that's a great question. So just the other day, I was Googling my own name and saw on there that there's another person with my name in the community doing financial services, completely different from my type of financial services. But, that person was right beside my name. And I thought to myself, well, it's not illegal if he has my name, right?
But if he put the little compass thing.
Yeah, that'd be misleading, wouldn't it?
Right.
And what could I do to protect myself? I don't know. And I think we've got a trademark a long time ago, but I can't recall. We've been in business a long time. I just honestly don't remember.
So Lauren, once you get a trademark, do you have to put TM next to it every time you use it, or what are the rules?
No, so when you use the TM, once you file for, you can use it once you file on the principal register, or you use the TM if you did not make it onto the principal register and you're on the supplemental register. So I know that out of context, that means absolutely nothing. But the U.S. Patent and Trademark Office has determined that there's kind of two levels that we can register trademarks at. The principal register means that you have first class priority rights over anyone else using the trademarks. And then the supplemental register are for marks that were maybe not as arbitrary or fanciful as some marks. And so they don't function as well as some other marks. Or maybe there is already a mark that's confusingly similar, but it's still deserving of trademark protection. So then they put it on what's called the supplemental register. And that's what the TM means. The circle R means that you're on the principal register. And that means that your trademark is so good and it's priority rights over everyone. What makes a good trademark is something that's very arbitrary. So if you think of something that applies to like Kodak for cameras, you wouldn't hear the word Kodak and automatically think that it applies to cameras. So the fact that when you hear the word Kodak and you think of cameras, that makes it a really good trademark because that makes it stand out in the industry or in whatever industry it's participating in.
That's really cool.
Something like, it's something that is a really interesting concept in trademark law is genericism. So if you make a mark, you want people to think that, right? You want people to think like, well, if I grab a Kleenex or, if anyone grabs a tissue and they think Kleenex, then they're automatically going to think about my brand and everyone's going to only buy Kleenex, but that's not really what happened. People think of Kleenex and they just think of a tissue that you blow your nose with. So it's bad from a marketing perspective that you could lose your trademark rights, but that's really what you want. That's really, it's kind of a thing that's always been at odds with itself. Another good example is crayons. Crayons was actually a trademark of Crayola, but because people just always called it crayons and never ever called it wax colors, they don't have trademark rights in the word crayons anymore. Now crayons is a generic term for wax colors.
Interesting. Yeah, I'm starting to see, I think, the importance of this, certainly for just even a small company like ours. I would never, right off the cuff think that I need to go ahead and trademark anything. But we too, with, specifically the word security in our name, Security First Insurance Agency specifically, there are several other insurance companies actually, and even insurance agencies utilizing the word security or incorporating the word security into their company name or a variation of it. So we have gotten phone calls specifically from a lot of policyholders, for example, in Florida, because there is a regional insurance company down there called Security Insurance. And so for whatever reason, when they're looking for that name on the World Wide Web, our company name probably pops up. But whenever Florida has a storm event of sorts, our phone goes crazy. And so certainly
World Wide Web.
Yeah, right. So I don't know. I guess if we had some type of a trademark, or maybe we're infringing on somebody's, I'm not sure.
Well,
I haven't really looked at that.
You bring up a good point, and Lauren, maybe you can speak a little bit to this, because you'd never obviously be able to get rights to security or first. I mean, those are words that are common in usage, and even security first in combination may not even be something he could secure. But what I understand, maybe you can speak to this, Lauren, is that security first insurance within the context of his logo, he can protect that, can he not?
Right. So I think it's a great question, and it's there are things that I would do when I'm filling out the trademark application, like disclaiming certain words that are not capable of trademark registration. So, for example, you're exactly right that the word security alone is not going to be capable of trademark protection unless you have already generated enough identification in the marketplace that people, as soon as they heard the word security, they already think of you because you've already spent billions of dollars in marketing and you've already secured that that type of recognition. Yeah, exactly. So so we could say, I want to use the word security, but I'm not going to use the word security without the word first. And so that first security, we could attempt to get a trademark registration on that. And a couple other things to think about is when you're applying for trademarks, you first of all have to show that you're using the mark or intend to use the mark within the next few months. And you have to show that you're using it on a specific good and or specific service. So if you're selling insurance services, that would be one application. And then if you also sell, if there's another service that you sell, or if there's any products that you sell, any tangible goods that you also sell using that same mark, then that would be a separate trademark. And your enforcement capabilities are technically, always caveats, always exceptions, they're only good as to that particular good and service. that you've registered your mark for. So if there is financial services and insurance services are really similar, so it wouldn't be, that's not a really good example, but if someone were selling pickles out of Florida using your trademark, you'd have to really show that that's causing consumer confusion in the marketplace for you to enforce your rights against that use of it.
And I want to probably, we've really covered a lot of territory today, from patents to trade secrets to the softer side of intellectual property. And I think limiting our discussion today to just kind of this overview primer stuff is good. But I do want to talk about in our next podcast with you some of what you would do to enforce, like what you're saying is, say someone does start, or you think someone's capitalizing off your brand some way, what are some of the steps we can take? But with this in mind, patents, trade secrets, trade dress, which when I think of trade dress, I mean, my personal experience with trade dress was Chipotle Mexican Grill, for example. For those of us,
yeah, it was a great story
Chipotle,
there.
they really developed that corrugated steel, wood. And another one is Lark Burger, which used very distinct wood paneling.
Lots of restaurants.
Yeah, a lot of them create their look and feel, and they are very intentional about it. And so I know restaurants, and that's why use the example of Taco Bell. So there's trade dress, and then there's just the obvious trade name, trademark thing, and just knowing kind of the initial steps that you've walked us through on what folks should consider doing to make sure they at least give themselves an opportunity to enforce and protect those interests. So I think that's been very helpful today to kind of do an introductory overview of all the things of IP. Let's do on our next podcast talking about, so you have IP, what now, right? So with that in mind, I just want to thank Lauren for joining us today. I know I kind of dominate some of the questions. This is an area I find fascinating, and I guess being a lawyer, I just know some of the nuances, so I tended to dominate my leading questions to Lauren. But perhaps when we come back, Carl and Jeff can really get into some of these issues of how to protect. So,
well, we look forward to it. Thank you so much, Lauren.
Absolutely. Thanks, Lauren.
Thanks so much. Thanks.
Thank you for joining us today. Hope you enjoyed the information we shared.
If you enjoyed this podcast, please feel free to share it with someone else, and join us next time.
If you want to meet with a member of the team, please contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
If you have special topics you'd like to hear about, please reach out to us and let us know at the same email address. Again, that's info@expertnetworkteam.com. Thank you for joining us, and have a great day. Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the firms represented, nor does it constitute legal, investment, or accounting advice, and the views are those of the professionals only.
Investment advisory services may be provided through A&I Financial Services, and securities may be provided through Genios Wealth Management.